Good afternoon, ladies and gentlemen. We are here for the intellectual property panel discussion. Our topic for today is climate change, SDGs, those are the sustainable development goals, and adaptive innovations, and placing the intellectual property lawyer. Okay, with me here, we have 4 distinguished panelists, and I will introduce them, starting with Mr. Paul Asimwe, to my right. Mr. Paul has over 2 decades of intellectual property experience in Uganda. He is also a partner at Law Advocates. Okay. All right. So Mr. Paul has over 2 decades of intellectual property experience. He's truly one of the greatest pioneers in this expertise of intellectual property. He has engaged SMEs on IP issues. He's also the former chair of the National Intellectual Property Advisory Committee, that is NIPA, which is under the Ugandan National Council of Science and Technology. He has also provided legal counsel to foreign companies and foreign or regional organizations. You're welcome, Paul. All right. Immediately next to Paul, we have Miss Eliza. Miss Eliza is also a seasoned intellectual property management professional. She has, with a focus on agriculture and science and technology, STIs. Currently, she is the Senior Incubation and Commercialization Officer at the National Agricultural Research Organization, that is NARO. And she has a significant experience in commercialization and fostering collaborations between NARO and industry stakeholders. And also she has a Bachelor of Science, Technology. So she brings a very unique expertise to our panel discussion today. You're welcome, Mr. Eliza.
Thank you, Paula.
All right. Then we have Miss Judith Kagere, who is an advocate and an associate with AF Mpanga Advocates under the Intellectual Property, Technology, Media, and Telecommunications Practice Group. She has 5 years' experience in IP, and she's handled various transactions in this area. She also holds an LLM in corporate and commercial law from the University of Dundee, and she has been trained by the World Intellectual Property Organizations Academy, the WIPO Academy. So she brings also a very interesting perspective to IP, IT, trade, and innovations. You're welcome, Ms. Judith.
Thank you,
And then we have Dr. Anthony Kakoza. He's an intellectual property and cyber law expert. He is currently a lecturer at Makerere University, and he's currently a lecturer at Makerere University School of Law. He is formerly the Dean of Law from Uganda Christian University. He is also visiting professor at several universities in Czech Republic and in the USA. He also dabbles as a traditional knowledge and folklore expert. You're welcome, Dr. Kakoza. Right. So for a brief about our topic today, which is climate change. And so climate change does pose significant, of course, challenges when it comes to the sustainable development goals. We've got food security, clean water, sustainable cities and communities. And of course, achieving these SDGs also often requires that we have innovative solutions, particularly in areas like climate change. Climate change itself is also one of the 17 UN SDGs. So adaptive innovations ensure the creation and implementation of new technologies, practices, and products that help societies adapt to climate changes. So of course, intellectual property plays a very critical role in fostering innovation and providing incentives for developing new technologies. And so today we're going to hear from our panelists on this climate change and then related SDGs and adaptive innovations. And also, as an IP lawyer, it's pertinent for an IP lawyer to understand the complexities of climate change, SDGs, and adaptive innovations, which are essential to supporting the development and dissemination of intellectual property and all these related assets. And we can get right into it. I will give at the end of the panel discussion maybe 10 to 15 minutes for our audience that is online to ask questions to any of our panelists. And I will ask Professor Dr. Kakoza to, Prof, you've studied a lot. Yes, so I will definitely give you the honor to take us through the relationship between climate change, sustainable development goals, and then in what ways do adaptive technologies play a crucial role?
Okay, thank you very much, Paula. That's a very interesting question. Really, it sets the ball game in terms of what this theme is all about. Issues surrounding climate change are at the fore of various discussions, and in any case, sustainable development goals and climate change has been the theme, or still is the theme of the World Intellectual Property Organization's focus on intellectual property for this year. When we talk about climate change, our understanding is that in the simplest way of looking at it, the climate is changing. The earth is getting warmer and therefore releasing a lot of gases into the air and causing heavier rainfall than normal, causing heavier or stronger winters than normal. And that is affecting humanity. The ecosystem is changing along the way. That people do not go through their life cycles, not just people, but the whole environment doesn't go through the life cycles the way they're supposed to be. The crops getting destroyed and humanity being destroyed outside of the way things are supposed to be in the normal realm. And the sad reality is that we are the ones, the occupants on the earth, mainly human beings and not animals, are the ones doing this to earth. So we are the ones negatively affecting the climate. So because of those changes in the climate, we need to adapt to the new normal, the new negative normal. And that's where the phrase adaptive or adapting comes in, that you're looking at a new set of the way things are turning out, and you need to now employ strategies in place that address this new negative normal. Why are we having warmer summers for those that have those seasons, and why are we having colder winters for those that have them? And what technologies can we put into place to kind of mitigate the situation? So when we start looking at those technologies that need to come into place to mitigate the damages that we're doing to Mother Earth, is where you start now thinking intellectual property, because those technologies are about creativity and innovation. So various parties come together and start looking at that. So when we bring in the Sustainable Development Goals, these started in 2015. They were established by the United Nations, being all the member states of the United Nations, coming together and saying that let's set goals in place by 2030. What are the 17 things that we need to focus on to change the trend of the way we're looking at humanity? And I can't list all the 17, but they may look at eradicating hunger. They're looking at better health care, better food security, gender equality, and the one that as intellectual property lawyers we always focus on is goal number 9, which is on innovation and protection of technology and things of that nature. But when you stretch out all these goals, we see that it's not just goal number 9, but all the 17, there's an aspect of intellectual property here and there. Our focus on how do we address climate change, it's pretty much in addressing all those 17 goals. So I think in a way that answers the question. Thank you.
Thank you so much. All right. Thank you so much, Doc. So I guess I'll just pass the torch to Miss Judith, just to break it down for us. How does intellectual property law intersect with the development and deployment of these adaptive technologies that are aimed at combating climate change?
Paula, maybe I would answer that question within the Ugandan context. If you're looking at, your practice as a Ugandan lawyer, or even just as a Ugandan, and what we can do to combat climate change, you have to look at it within the kind of socioeconomic problems and challenges that we have as Ugandans, but also looking at how, the intellectual property practice knowledge that you have and the different subsets of IP and how they intersect within those different circumstances in our community. So intellectual property as it exists does not change. We still have the same regimes, applying in the modern world and with the different problems that we have today as a society. So you still have innovators creating software and different applications that will still require copyright protection, and they still need advisory regarding that. They will still have brands and names and logos, and those will still require protection. They do not suddenly not need to be registered or not need any type of enforcement in the new world that we have. But you need to look at it not just as the different regimes that we have, but how our different clients are going to, begin to innovate and the kind of different advisory that they may need. To put it in context, for example, with climate change, you're going to find that for Uganda's context, intellectual property, I think we would need to look more at the different culture solutions that we have, the different traditional knowledge that we have within our communities. I think it's time to go back to our communities and look for the solutions there. I think for Uganda, the solutions are going to be within, our different communities and our culture. So I think, I know Dr. Kakoza has a lot of knowledge on traditional culture expressions and traditional knowledge, but he will tell you that they do offer solution. For example, Uganda is an agriculture economy, if we're to take a look at that sector. So you'll find the different kind of practices that Ugandan farmers have, like crop rotation, intercropping, biodiversity, agroforestry, all those different kind of practices that they have are their small contribution towards climate change and sustainability for the earth as we have it today. So for an IP lawyer, you'll find that your clients within this space will turn towards how can they protect maybe their different products that they have, like different natural products that they have. Can they be able to get a trademark for it? How can they be able to commercialize and make a little money within that kind of advice that maybe you can begin to think about giving them? But for Uganda, I think it's important for us to look at how each of us can begin to understand the little role that each of us play within the climate change fight. Yeah, so I think that's how I'd answer that question.
Wow, interesting. That actually, when you put it into the Ugandan perspective, yeah, you introduced something that is very, very interesting. Using our traditional knowledge to combat climate change challenges that we have, which is quite interesting because I know that intellectual property is both an enabler, and it also has a restrictive role. The fact that we would have to look, from within. And so I have a very interesting question for Ms. Eliza. When it comes to the deployment of adaptive technologies, presumably from here and from without, is the Ugandan IP system an enabler or a barrier to the transfer of climate change technology?
Thank you so much for that question, Paula. And I would like to take us back to what you mentioned earlier, actually the main purpose of IP, which is to make sure you're fostering innovation processes, but also giving incentives to those people who are innovating. So in a way, IP is a tool for technology transfer. So in narrow, we look at giving the narrow case. I think it's a good one to demonstrate how it can be. So as I said, we develop a number of varieties that are addressing various aspects of climate change. And one of the ways that we are using the IP system is by licensing these varieties to the private sector. We think that private sector is very critical when it comes to dissemination of the climate smart technologies, because one, they are more efficient, they put in resources to market and reach the last person. If we leave everything to the government to do, there are some people who need a certain technologies who will never access it. So we license our varieties to seed companies who multiply and make sure that it is available to the different regions within the country and to reach the people who need it most. Now, IP system in Uganda, we have very elaborate IP laws. We have a national IP policy, we have institutions, but I think in my view, there is a limitation where this IP system has been developed kind of in isolation, and this one mostly affects the public sector. So for example, in Naro, we have our law that establishes Naro. We are given the right to own IP and to even commercialize. But we cannot do some of these things because other government policies, for example, the policy, the is it called Procurement and Public Act, PPDA, yes. And then we also have a limitation when it comes to the financial management, the public financial management processes. So for example, we go through the process of licensing, seed companies come, and at the end of the year, they're supposed to remit royalties. But we are required, because we are a public organization, to again remit those funds in royalties to the consolidated fund. This goes, it goes beyond, against the principles of IP, because it's supposed to be an incentive. But now if we have to remit these royalties to the consolidated fund, then the incentive ceases. If you know anything about government, getting funds from the consolidated fund back to do what it's supposed to do, to develop more climate smart technologies, becomes different. So I think the limitation in the IP system is that it is a bit isolated. The other government procedures and policies are not supporting the IP system to do what it's supposed to achieve. So we have enabling environment, but also limitations at the same time.
You've introduced something quite interesting that I'll touch on a bit later, on the IP system being isolated from all other government policies. And you also mentioned licensing of the variety of these seeds, from Naro, which is quite interesting because even in licensing itself, of course, you've introduced something that I feel Paul should talk about in terms of, we have IP laws and policies, and the IP law is meant to, in one way, to reward the innovator. Licensing fees, selling your product, your patent, commercializing your asset, and at the other end, we also have to balance interests and also protect public access to some of these. For example, the seeds, what's the cost of licensing? Is it affecting access, for the poor people somewhere in Uganda? And my question to Paul, how can we have IP laws and policies to be structured to be in a way that protects innovations and innovators, but at the same time ensuring that crucial climate technologies are accessible, especially in our country, being a least developed country or in developing countries?
Thank you very much, Paula. Good afternoon, fellow panelists and those that are online as well as in this room. I think we're basically trying to see, responding to your question, how we can mediate between, I think, public sector interests and private interests in order to foster the objective of availing these technologies, these products, these solutions. I think primarily I would just say that there will be two approaches. One is, for me, the one of the market. I feel I'm a very strong believer that the market is one of the primary arbiters where you have issues of access to a product or to a service, okay? First of all, put the product on the market, okay? Now, let's be kind of more practical here, and I'll give two examples. One is a climate smart cook stove, okay? I'll bet you that none of the panelists here have a climate smart cook stove, most probably because it's not available in the country, okay? There are a few that are available, but the market is very, I mean, their availability, is quite constrained, okay? There's one that I think I recently saw online. I tried to reach out to them, and they're available in Kenya. They're also available in Rwanda, but they're not in Uganda. So that will tell you that the market in Kenya and the market in Rwanda are more responsive, okay, to new products and new solutions in that area than we are, okay? So I would still say that we need to have the government create a conducive environment for these kinds of products or solutions to be available. The second one would come where market failure exists, essentially where you have a product that is too expensive, where the product is too expensive, okay? So let us say that you have a new technology or new cook stoves that are supposed to be saving the environment in terms of reduced energy costs and so on. But it is priced beyond what people can afford. And the Industrial Property Act clearly provides for cases where you can have compulsory licensing, where the minister who is in charge of this implementation of this law can actually intervene and say, look, we have a patent on this cook stove, and we are going to intervene as government to ensure that instead of this cook stove, but the second scenario cannot come into play when the product is not on the market in the first place. And so for me, that is how I see an interaction between the law and trying to enhance access to these very important and useful products in this area.
Thank you. Thank you so much, Paul. Ms. Judith, as an IP practitioner, we were just discussing basically, how we can have policies that can be structured, to protect innovators and innovations, in line with what Ms. Eliza discussed with us about licensing fees. And I don't know, do you have something to add on how we can have our policies and laws, to cater for the innovator and also to cater for public access?
Well, currently, I think most of us are aware that Uganda has the national IP policy. That was 2019. I think it's making 5 years this year, I think. The national IP policy and also its implementation plan, it's quite intentional and also achievable. Achievable in the sense of the different stakeholders that have a role to play in terms of how Uganda's place in intellectual property in this coming decade. For example, NARO and URSB, Ministry of Health, Ministry of Education, and different government stakeholders, you'll find that there are interesting roles that everybody has to play in terms of educating the public and also awareness on people's different IP rights. I think we've not come a long way, but we've made some type of headway in terms of awareness. You'll find now people are more conversant with what may constitute, their name may have some type of trademark protection. They realize that if I'm creating something, I'm coding on my computer, there may be some type of copyright I may be able to get out of this, and also bringing that knowledge down to the community, especially the youth. For example, in the innovation hubs and the universities, and Makere just opened the AI lab, and it's a state-of-the-art facility. And I think if we're able to leverage it, we'll be able to go a long way in terms of knowledge as a resource, but also in terms of handholding the public and making them more aware of what they can create and how it can be protected. It begins with knowledge and awareness. When people are aware of what they have, then they are empowered as regards what can I do to commercialize this. For example, the young people, when they're creating in the innovation hubs and their different technology hubs, when they have more education on copyright protection and utility model protection, then they can also subsume that kind of knowledge within their innovation cycle and see that I'm moving from ideation. How do I value my IP when I'm creating this software? So once they're able to have more knowledge, then they can be able to commercialize. Commercialization doesn't end, and it's more on us as the lawyers to guide them. Are you going to license? What type of contractual framework are you going to have? But on their end, once they are aware, then I think then there will be a lot more progress as regards commercialization. I think URSP has done a commendable job as regards awareness within the public. They have done a lot of outreaches in every single region of this country. I mean, even to do with copyright and the different kind of IP spaces. They've gone down to the universities, innovation hubs. They've talked to almost every single young person, and it always begins with the youth, I think, because Uganda is a young country, and we are the future. So it's important that when we are educating, that the youth are at the forefront. So for me, commercialization all begins with awareness within the community.
Thank you so much, Judith. So basically, as intellectual property lawyers, our role is a bit multifaceted. We have to protect the IP rights, then we have to promote the technology transfer, the development of policies, and we have to do all that and ensure that they align, with global sustainability, goals, and then national interests and all that. And so I'm really curious, and I'd like to hear from Dr. Kakoza. What specific roles can an IP lawyer play in, facilitating innovations that address climate change and also advance SDGs.
Thank you very much, Paula. Hello? Okay, I think it's now on. Thank you. Yes, thank you, Paula, for your question. I wanted to, before touching on the role of the lawyer, because that is, again, the key question why we're here, I wanted to supplement on what Judith has been saying as to the whole, should I say, the regulatory ecosystem on climate change as far as Uganda is concerned. Uganda has always been highlighted as very good on what it has on paper. But when it gets to implementation is where we have the question marks. But I would dare say that's not so much the story for how we've addressed climate change. The records show Uganda was the first country in the whole of Africa to actually sign on to the United Nations Framework Convention on Climate Change back in 1994. We have a climate change policy. We've signed on to the Kyoto Protocol. We've signed on to the Paris Agreement, which are obligating the country on ensuring that gas emissions do not go beyond 2 degrees Celsius. And how have we implemented on that? That's where you start hearing the stories from Elias and what NARO is doing. So the adaptive technologies are there because we are obligated under those international frameworks. Then we have, of course, like I've mentioned, the climate change policy. We have the Plant Variety Protection Act as far back as 2014. But then now the question comes on the regulations. I know they were drafted, but they're probably sitting somewhere on someone's desk and haven't yet been rolled out. So that's where we need to employ the push and shove to see that these regulations come out and we can practice what we are preaching. But beyond all that, the role of the IP lawyer then comes in. The lawyer is normally guided by the framework in place. So I've mentioned the international and, well, just mentioned the international framework that we are on to. There's the Arusha Protocol under ARIPO, the Africa Regional Intellectual Property Organization. So it came up with the Arusha Protocol on plant varieties protection. And interestingly, although it's a Ugandan who chaired the sessions leading to this protocol, we haven't yet signed on to the Arusha Protocol. So that calls a lot on what are we doing? We need to take on the Arusha Protocol, because what the benefits that the Arusha Protocol brings to Uganda as a member of ARIPO would be we broaden out our market and consultancy base amongst the 22 member states of ARIPO. Part of what Paul was saying about expanding the value chain and the markets, access from the market on various strategies in place on adaptation. And even beyond that, consultations among the 22 member states and also from the big players on technological transfer would help us. And the lawyers are at the forefront in pushing for technological transfer. Then we have other stakeholders, the scientists, who I would say are the ones working in the kitchen on how to address these issues on climate change. But when they don't have lawyers at their side, then they're only fulfilling part of the story. They will come up with the technological innovations, but if they're not guided as to how to protect them, then you would have those who know that there's something big happening here and they would steal this information and take it elsewhere and utilize it. But because here we're coming up with rolling out one innovation after another, and the lawyers are not guiding on non-disclosure agreements before you sit in a boardroom. They're not guiding on freedom to operate, to say that, okay, yes, this innovation is protected, but there's this open door here where we can still be able to access it or utilize it, or even guiding on licensing agreements. Then we're not really fulfilling the whole process. We're only drawing part of the story out of here. So, yes, lawyers have a bigger role to play in those regards. Licensing agreements, mainly, helping out in consultancies and broadening out awareness on tech transfer. Thank you.
Thank you so much, Dr. Kaboza. Eliza, from your perspective, because you are on the other side of all of the innovations that we're talking about in climate change and agriculture, what's your opinion of you on the role that IP lawyers can play?
Okay. I would like to first start with what Council Paul mentioned. These products are not on the market. And he gave a very good example of the energy efficient stoves. When you actually go into the R&D institutions in Uganda, even in academia, you find so many innovations. And anyone who has been in the innovation space, I think you're very familiar to the phrase, technologies are stuck on the shelf. So that is the actual problem. Why are technologies stuck on the shelves? One, maybe I should emphasize that I'm not a lawyer. I am an incubation and commercialization officer. So part of what I do, this is incubation, we try to refine the research products so that they become a market product. Right now, somewhere in Naro, we have almost 6 tribes of energy efficient stoves. But I can assure you, if I'm to sell it to you, Council Paula, you're not going to buy it because it has not gone through a certain process that makes it ready for the market. And that process is what we call the technology incubation process. It is a process that requires investment, and oftentimes when your mandate, such as NARO, is to do research, once you've delivered that product, you've gone past the proof of concept, you feel like you have fulfilled certain obligation. And that is why we ride on the private sector to come in and pick from there, hopefully incubate, and then commercialize. But the private sector, in Uganda at least, is not willing to do that. So you find that government or the public sector has to push in extra, and private sector wants to pick it when it is ready for the market. So there's always that gap where there's no willing funder or someone to step in the gap to make sure that technologies are no longer on the shelf, but actually reach the end user. Now, having said that, again, I'll go back to NARO. Our approach when it regarding technology transfer, we have 2 main approaches. We have what we call the public route and then the commercial route. And the main reason as to why we have these 2 routes is to make sure we are reaching all the people who need to access the different technologies. So with the public route, we're using public infrastructure, public institutions to make sure that if it is seed, it is reaching that farmer and they're using it at the local facilities. It doesn't attract royalties, no need to sign any licensing agreements, it is simple. Where it becomes a little bit complicated is in the commercial route. I mentioned before that we have gone into licensing, and it is not as simple as you'd think. In NARO, the IP management unit, unfortunately, has 2 scientists and no lawyer. So, and technology transfer is mainly science, technology, innovation, business, and the legal aspects. So we do very well on the technology, on the business, not so much on the legal aspect. So there's a very big role for IP lawyers to play in that regard. I want to get deeper into the licensing. Right now, as I mentioned, we do variety licensing, and when you think about variety license, what you think about when it comes to IP is the PVP, the plant variety protection. Unfortunately, right now in Uganda, there are no regulations. So as NARO, we're not able to register our plant varieties. So the question is, how are you doing it? Yeah. So one, there is such a thing as an unregistered IP. So we have our varieties, and we are considering them as unregistered IP. The seed system is designed in such a way that the different classes of seed can only, the first class of seed can only be managed by the breeder. So the fact that we are able to control the breeder seed gives us some a way in which we can control who can access and who cannot access. So because we have that advantage, we are able to enter into licensing agreements with seed companies. Now, these licensing agreements are not on the basis of the PVP, but contract law, and that is where the saga begins. It is very difficult to enforce your IP rights via contract law. Now, I'm not a lawyer, but in practice, the communication that you have to do with the seed companies, the ones who are complying, the ones who are not complying, it becomes difficult to control quality. So much as we've had some success in terms of licensing our varieties with the seed companies, it is very challenging. We're not achieving the goals or objectives that we have simply because we are using contract law, and the absence of that PVP regulation makes it very difficult. So if we continue with this contract law business, we need an army of lawyers. So thank you.
Wow, that's enlightening. And I guess to the IP lawyers, we are clearly there is a gap that we are not filling up, because, you know, as intellectual property lawyers, we are facilitators of innovation. We also guardians of the legal rights. At the same time, we also have to be advocates for sustainable and, you know, equitable access to technology. And all of these are essential. And Eliza, thank you so much for sharing with us and enlightening us that maybe perhaps we are just too closed up in our law firms and we need to step out. There's a lot of legal work related to intellectual property that we can actually do out there. And that, Paul, I'd like to know, what are those emerging trends in intellectual property, now that we're talking to and about the lawyers? What are those emerging trends in intellectual property and the climate change area that lawyers should be aware of? And how can IP professionals or lawyers generally prepare for and address those future challenges that are related to IP and climate change?
Thank you very much, Paula. I think, for me, I think the most significant thing that I would like to have our IP lawyers be aware of, the most significant in my view, is a program that WIPO is running, started about 3 or 4 years ago, called WIPO Green. So WIPO Green is basically a repository of knowledge, know-how, contacts of IP owners. So again, let me go back to the cook stove example, okay? I am here and I see the possibility of supplying clean cooking stoves, equipment to 100 schools, okay? That is a very significant opportunity. But I may not have the in-house resources to do R&D, to come up with a brand new cook stove. So what do? I'll go to WIPO Green, and if you have the right or the properly paid lawyer like Professor Kakoza, he will check the system with the right international patent classification to ensure that he is actually looking for the right the right kind of innovation. And you will be able to see the products that conform to the kind of product that you're looking for. So let us say that you get 30 or 40 patents, you will keep on narrowing it down. And one of the very important things that I think we can also learn from and hopefully see URSB implement is that you have, together with the patent information that says clean cook stove uses ethanol or uses a solution, an energy source that is available to you, is that it will give you the contacts of the actual patent owner, okay? And even in some cases, it may give you a price range of how much you need to pay to license this know-how. So all of this cuts down a lot of what we call, you're in the kitchen cooking these cook stoves. You're cooking them and they're cooking you. But nothing is getting on the what? On the marketplace. And me as a potential customer, I also don't know that you're in the kitchen. I have a problem, but that problem is not being met by your solution. So for me, I think that this is a very, very significant platform that IP lawyers need to be aware of, because you may be sending your clients to China to copy Eliza's product, when in actual fact they could actually legitimately get a license from someone who has already patented it. And this is something that we've had, I've shared with the Registrar General, and I hope we can push the concept further, because this may not only apply to green technologies or climate smart products. It could relate to, we have a massive problem with the availability of sanitary pads in our schools for young ladies. And you may find that on WIPO Gold, or even on our own patent database, we have patents that are not being worked. Patents that are not being worked essentially means there is no manufacturing or availability of that product on the market. And yet you have some gentlemen who will be able to open a shopping mall for wife number one Naluvega on Loom Street, another shopping mall on another street, and so on. That shows you that we actually have a lot of local money that could do really important things. But there is an asymmetry of access to the know-how, and the IP lawyers, I think a lot of us, and I take the blame as well, we are really focused on transactional IP, which is basically register the patent or the trademark and throw away the file, okay? Now it is a digital file. Archive it until it needs to be renewed. But I think we need to be now challenged to move beyond that, to actually have an interface and challenge our Registrar General to see whether we can actually have a similar portal that shows the nature of technologies that are available in different spaces, okay? And then, because you will never reach that point where you're talking about compulsory licensing when you don't know what you actually have. You need to be able to query that system, and even if you don't, you can just prioritize and say, in this area, in this IPC category, we have 10 very important patents, okay? And you will then subject that and interrogate that to actually, are these patents in use? Which companies are actually putting products on the market? What is the value of the products that those companies are putting on the market? I think once we have that knowledge, we will start making better use of the IP system, and I think we'll be in a better place. Thank you.
Thank you so much, Paul. As we come close, I think we are past our halfway mark. But I'm just curious to hear from Dr. Makosa, just some examples, of specific case studies, basically, where IP has either facilitated or hindered, the deployment or development of adaptive technologies, especially now that Paul has told us, you don't have to reinvent the wheel all the time. Sometimes the information is already out there, and you can advise your clients better. And so, can you share with us some very specific case studies?
Thank you. So, we're talking about climate change and innovation in this area. So, the areas are, how are we using technology, first of all, in renewable energy? And Naro has case studies in that area. when we drive around Katwe area, there's that huge workshop, carpentry workshop and the likes. And I've always wondered, what do they do with that sawdust and wood dust? Now, a company like Narrow has gone into doing some research on sawdust and wood dust and discovered that the fire that you can generate out of sawdust would be an alternative to someone who uses charcoal. Charcoal emits some gas emissions, which are against what we're focusing on with the Kyoto Protocol and the Paris Agreement. But why can't we now turn to the technology that comes from sawdust and wood dust? So that's one way in which we're now using technology to deal with climate change, and that's positive. We have, of course, the case of the Kayola buses. That's now turning to electricity vehicles. We're talking about that at the sideline, that why don't we, because this is a government project. The Kayola buses, the EV bus project, was a spin-off from Makerere University, I think one of the colleges. And they're now saying they're going to be rolling out so many buses every month. So why not say that these buses should be the ones running in the central business district as well as all the municipalities spread around the country. In that process, they reduce on pollution in the central business district and in the urban areas, and then we ensure that there are regulations in place, that the taxis and these borders have spots where they stop. They don't get into the city. It's only the buses, which are government buses, that are running within the city. There you're able to solve pollution issues, you're able to solve traffic congestion issues, and people are focusing on just these buses, and being that it's a government project, that the money is just running within government. So you have a multiplicity of issues there that you solve through a technological solution like that. But because we're talking tech, and I'm just picking out 2 examples out of many. Oh, there's also what PBID is Presidential Initiative on Banana Industrial Development, which is also a spin-off from Makerere University, a project by Reverend Muranga, where she's done a lot of research into what you can do out of bananas, apart from eating them. She's come up with some very tasty cookies that are quite nutritious and help in diet control. The last I had, there was also some research on creating hair weaves out of bananas, and a variety of so many other things that are coming through the banana research project. But you need to protect these technologies. You need to protect these innovations, and where intellectual property comes in protecting them, it's where we understand why we call intellectual property a negative right, that whoever owns the IP is dictating the terms and conditions as to how you can utilize it. You have to pay because this person wants the royalties, and this person determines how you're going to use their intellectual property. So you may want to tap into the benefits of all this technology that I've mentioned, as well as the various other technologies that are out there. But if you don't fall within the terms and conditions given by the patent owner or the utility model owner, then you are missing out on those benefits that come with that IP. For instance, if you have plant breeders, yes, our law is there, but it's not there. We have the Act, but we don't have regulations that are putting the Act into place. But let's say we had those regulations in place. Uganda is an agro-based economy. And with all these cassava breeds and rice varieties, farmers want to share in this technology and expand on how they engage in subsistence farming. But the plant breeder will come in and say, do not use my varieties because that's my intellectual property. So that's the negative right that we're talking about here, where intellectual property is making the one who wants to enjoy it not to get it because they're not falling in line with the terms and conditions given. So they should have exceptions in place. There's what they call farmer's privilege, that if I'm a farmer, I should be able to capitalize on the seedlings that are coming from this breeder and share with my fellow farmers, so, because we're looking at feeding our families, and that's the key thing. Remember, we're talking about sustainable development goals, some of them being zero hunger and eradicating poverty and food security and all those things. So there should be that balance between the rights of the intellectual property owner as well as the ones that want to use those rights. Thank you.
Thank you so much, Dr. Vakoza. Interestingly, what has been cutting across, uh, first of all, Eliza introduced us to the different steps that they go through developing these seeds. There's the innovation part, there's the business part. With business, we have licensing, we have technology transfer, and then we've got the legal aspects, policies and all those things. Then we've got commercialization, public-private partnerships. And then you've also introduced, negotiations. Yes, the IP can be a barrier, but then what I see are all these roles that not only intellectual property lawyers would have to jump into, but generally lawyers. Like for every step of innovation, of adaptive innovations or technologies, there is a step and there is a role that a lawyer has to play, basically. And at this point, I realize we have just a couple of minutes, about 10 to 15 minutes. I do not want to stretch our session. And before I invite our panelists to each give us one, final opinion on everything we've discussed today, I want to first open up to our participants that have graciously honored the invitation and showed up in case you have any questions. Absolutely. So I don't want to lose that opportunity to hear from you. So if you want to direct your question to a specific panelist, thank you so much.
Any hand up? Okay.
Thank you so much. My name is Nanyonjo Grace Aaron. My first question will go to Dr. Anthony Kakoza, and it concerns traditional knowledge. Now, in the quest to fighting climate change, mitigating climate change, and adapting to climate change, the constituent of indigenous communities has been put out there as key custodians of traditional knowledge that is pertinent in abating climate change, at least in all the international negotiations. Even as far as last year, they featured as a key contingent in the global stocktake, as people are going to be very key in abating climate change. So, so my question is, and one of the biggest threats to traditional knowledge is the accelerated biodiversity loss. So how do you think we can regulate and protect traditional knowledge to avert climate change? Because with the continued loss of biodiversity comes with the increased climate change. But also we have to bear in mind that one of the biggest issues with traditional knowledge is that it's not owned by one person, it's tied to the identity of a community, and it's passed from generation to generation, most especially because it's not usually documented. So how can we best regulate traditional knowledge, protect it, if not for only IP purposes, but also for purposes of averting climate change? Then my second question is, it goes to the lady from Naro or Mr. Paul, any who can answer. Now, we noticed that most of the technologies, at least from Uganda, most of the technologies steer towards adapting or mitigating climate change are mostly from private people. People who come up with these technologies are mostly private people, usually people who are not so known, people who are just innovative and creative. Now, how best, in the spirit of compulsory licensing, how best can government work with the private sector to ensure that, yes, these technologies that benefit the whole community can benefit everyone, but also ensure that the private innovator also is recognized and can also commercialize and make profit out of it, because there are so many technologies in this space. Even we see people who have electric bikes, and they say, now for us, we are a private sector. We can't subsidize because we have to make profit. But electric bikes are modes of transport that could perhaps help people in villages. Then there are also technologies maybe in the space of filtering and accessing drinking water. There's that one where you access drinking water without boiling, but it's also a private venture. So how best can government work with the private sector to ensure that it's a win-win situation? Because now there's a bit of apprehension. I think there's a case we had of Zenod. I don't know whether it has been resolved, but the issue was that, yes, these were private students who came up with a technology that was going to ease management of exams or administration of Chambogo University. Then it became a full-blown court battle. Then from then on, when you interact with a few government officers, they'll say, when government is going to work with an individual, now a key priority is that it should own full IP rights to avoid this back and forth and maybe fighting with private individuals. So how best can government work with private individuals so that both sides can win and benefit from the collaboration? Thank you.
I think we can have the questions addressed. Dr. Kozma.
Thank you, panelists. I'll start by recommending the government for the new curriculum in education that tapped into some bit of creatives to try to bridge a gap that had been lost over time. I grew up in an era where we had science fairs program at school. I'm a student of St. Jude Primary School, Namguru, and we had a science fair in 2001, 2002, which had been lost over time. And I think the new curriculum has put it into. My concern goes to the representative of Naro. You shared that there is a deficiency of not having legal persons on your team, and you end up having only scientists that end up maybe drawing a contract to execute and deal with other persons in respect of specimens that you're testing in the public. Or I am a very good person that buys newspapers. Even today there's a newspaper with job articles, job adverts. I've not seen anywhere Naro is seeking or calling upon lawyers to respond to, and lawyers have declined to do so. I think it is a deliberate act by persons within the management to sideline. At times, a science and a legal professional, science may need to test. And now for us as legal professionals, we look at all sides of a coin. Maybe that's why you don't have legal. But my question is to you. I don't know whether you're in authority to do so or not. Please make the advert. Lawyers are many. They will respond. Thank you.
Thank you. I think let's have these questions addressed, and if there's some more, we'll take them after.
Okay, thank you, Nanyanja Grace, for your questions on traditional knowledge and what can be done to use traditional knowledge combating climate change. So, as of course we all know, Uganda does not yet have any specific regulation on the intersection between traditional knowledge and intellectual property, although I would say we're in the final stages of getting this regulation in place. I've been involved with URSB and consultancies on regulation of traditional knowledge, and I remember a few years ago, as part of the research, we came across information about a certain rural community where people in that community have been trained to tell if it's going to rain or not by just looking up in the sky and looking at the weather, and they tell that yes, it's going to rain. How do you document such and how do you protect such is quite a tall order. But you're not going to find answers for everything in the law. One of the ways forward in such a situation is broadening out or revising our primary school, elementary school curriculums to have a voice for TK, a voice for traditional knowledge, a voice for the relevance of culture expressions and indigenous knowledge, so that people grow up not only knowing about what's out there in the Western world and Western civilizations, but as well as what our forefathers would learn at the fireplace is now also learned in the classroom, because more people can learn these things through the educational curriculums, understand the relevance, and then also be able to apply them. And that's not about the law, it's just simply changing the education system and broadening out how people understand and appreciate these things. So that's just one way forward. The other is, if we look at our Industrial Properties Act, it does already have a provision on patent disclosure requirements, or what you call PDR. Patent disclosure requirements are basically stating that if someone is applying for a patent, and there are aspects of that patent that involve genetic resources. Genetic resources is about anything that is growing in nature that, say, communities have been relying upon. Say, you know that this particular leaf, if I chew upon this leaf, my cough will go away. So that's knowledge that our grandfathers and the like know about, but we haven't documented it anywhere. And the practice has been that pharmacists come and they get such knowledge, and before we know it, they're already filing for patents in the same. But now they're being required, or at least our regulations already require that if you're filing for a patent that has such knowledge, you should be able to state that there's an aspect of my patent that involves traditional knowledge or traditional knowledge associated with genetic resources. So we already have this in our Industrial Properties Act, but in May of this year, the World Intellectual Property Organization came up with a new treaty on intellectual property, traditional knowledge associated with genetic resources, that also addresses patent disclosure requirements. So this is making it obligatory on every country that signs on to that May 2024 treaty to ensure that they have domestic regulations that protect such indigenous knowledge. So we are halfway there in a way. But like I've said, it's not only through the law that we'll have answers.
Thank you, Grace. I just maybe will respond to the question on how government can work with private innovators, I think, to get some products onto the market. Now, I think that the way that I would approach this is that not every solution in this area is going to be with an IP lawyer. And one of the things that I believe very strongly is that the government has different tools available to it if it wants to incentivize creativity, innovation, and so on. One of those tools, in my view, is fiscal policy. So your tax policy can actually create an appetite for a certain product or a service, or it can create a disincentive for people to consume that product. I will give you an example. In Kenya, when COVID struck and many businesses were paralyzed, one of the things that I found very interesting was that the government actually set up a fiscal incentive for companies that were willing to invest in low-cost housing. So essentially, across the board in East Africa, all of our corporation tax is 30%, okay? And the government said, we are willing to tax you, I think it was at a rate of 15%, if you are building 100 units, 100 houses or more, okay? So business people are business people. They are looking for, to make profit, and if you can give them a concession, that will still be taken into account, and you will get more people in that space. But the other thing is the example that I'll give, which is probably related to what we are discussing, is that I think last year there was a fiscal measure to reduce the taxes that imported cars pay. I think they removed all taxes excluding VAT. They removed import duty. I think they removed environmental levy and so on hybrids and electric cars. the example I'll give you is that in Rwanda, there are no taxes at all on electric vehicles. So you can clearly see that there was an advantage in Uganda, but there was a greater advantage in in Rwanda. So you're creating an incentive if you had people, companies actually manufacturing or even importing, because the goal here is to have as many people driving electric vehicles or people riding electric motorbikes and reducing on the greenhouse gases that are being produced. If you went to Ministry of Energy, where they are, I think Amber House, they have a very, very distinct charging station for how many cars? I think 4 cars. Now, honestly, we need to be serious. If we are creating incentives, let them be of some significance and have a significant impact. But the disappointing thing is that I believe that policy measure was even rolled back in the Finance Act of this year, 2024. So the taxes were put back, essentially making it look like a joke. You can't have a policy measure that lasts 1 financial year. It is showing a lack of seriousness. Why? Because if my friend Miriam there sets up a company and borrows $10 million to retrofit scooters or electric, these borders, convert them to electric, how long will she need, unless she is also smuggling cocaine, how long will she need to recover her investment? So if you have a tax measure in this finance bill and then you remove it in the next finance bill, you cannot create sustainable investment in that area. So we need to leverage the fiscal policy to meet the objectives that we believe will drive the country forward. Thank you.
Thank you. Before I start handing jobs to the lawyers, I'd like to also add something to what Council Paul has said. Just a small example. In the Philippines, they actually elevate these incentives to the level of laws. They have the Inventor Incentive Act, which provides for inventors to enjoy things like tax holidays of up to 10 years as they're investing in incubation and eventually entering into the market, having duty-free, is it like on importation of any materials that is going to exactly what he has said, but now for them they've made it a law. So I think it shows that they are very deliberate in terms of supporting private sector or any inventor that is doing some good work and willing to invest in making sure that the technology reaches the users. Now, lawyers and NARO. NARO has a legal unit. The problem with most government offices is that they are mostly understaffed. So for example, the technology, okay, I don't want to call it the technology transfer office, we call it the IP management unit in NARO, has 2 staff, myself and a colleague of mine. We are manning 16 institutes across the entire country. And it began as a 1-man unit. And the only way I could be recruited was by being innovative in my title. But we do the same thing. So one person is the IP officer, and I am the senior incubation and commercialization officer. We do the same thing. I draft patent documents, I conduct patent searches. He does the same, he handles commercialization, etc., etc. What am I trying to say? Government recruitment is very tricky sometimes. There are very many limitations, and even when management knows that there is a need for a lawyer to handle IP issues, specifically for NARO, they are not able to make those recruitments. So most of the times we are forced to depend on the NARO unit, the NARO legal unit, which handles so many things. They are handling the land issues, all sorts of things. And IP oftentimes is not the most urgent at any particular time. So we find that we have to struggle with the legal issues. We are busy drafting licensing agreements. We do have an IP management committee, and in that committee we have external lawyers that they have played a big role in terms of supporting us, but I am talking about opportunities for lawyers, not necessarily in narrow, but still supporting what we are doing. When we are entering into licensing agreements, we are entering into them with seed companies who need to be represented. When sometimes we are also engaging the what's that name of the association? The Uganda Seed Traders Association. They need representation. As I said, we are dealing with contract law. It is very, very complicated, and there are many legal issues that even when you're not a lawyer in narrow, you still have opportunities to partake in that whole process. So we pray that government starts to appreciate the role of IP in development generally, because not until we reach that point, we'll continue having the problem of understaffing. There are universities that I know don't even have an IP officer. So yeah, it's an issue of appreciating IP to the level that it deserves.
Thank you so much, Eliza. Maybe we can take one more question. Just one. Just please keep it short, and my panelists keep the response shorter. Because we are, I believe, out of time.
My name is Wahugo Michael. I'm from Uganda Registration Services Bureau, and I'm a senior traditional knowledge officer. First and foremost, I would like to thank the panelists. They have done justice to the theme of the day, and we would also like my colleagues to extend apologies from the Registrar General. She would have loved to be part of the panel, but she's engaged elsewhere. What I would like to add on to what the panelists have already said, maybe I should start with the aspect of traditional knowledge. Like Professor has rightly said, we are in the advanced stages of having a sui generis law to protect traditional knowledge and cultural expressions, but also to pass the announcement that next week we shall have a virtual seminar for legal practitioners, legal practitioners, R&D institutions, and then technology innovation support centers about the WIPO Treaty on intellectual property, genetic resources, and associated traditional knowledge. It's a recently adopted treaty, and Dr. Kakoza is going to be one of the panelists. So it would be very good for the colleagues here to participate or attend that virtual seminar. It will be insightful because Doctor is a consultant in this area, and he has been very active in working towards having this TK protected here in Uganda and also at WIPO. The other thing I would like to say is that IP has a lot of potential. If you look at the statistics, I think by 2022, global market value of IP, I think, was 8.6 billion US dollars. And it is projected that by 2032, the global market value will be 37.6 US billion dollars. So that shows you that intellectual property has a lot of potential. And this calls for the young lawyers, or for those lawyers who have not explored this space, to, take or seize these opportunities. Because from where I sit as working for the regulator, there are those common faces that have dominated the IP space. If you don't see Counsel Paul, you don't see Paula, you see Doctor, or some advocates in Marx, then there is no any other person you can really say that these lawyers are experts in IP. So this is something which lawyers need to take in interest because of the opportunities there. I'll give you an example of some areas in IP that we really need lawyers to partake. For instance, patent drafting. Ugandans are innovative, but they lack the legal guidance from the lawyers of how to draft patents. And this is an area which really needs focus. People are innovative, but the guidance, the legal guidance, is not there because most of the lawyers probably are not interested in taking interest in this area. Another area I can talk about is the geographical indications. We've so far registered one geographical indication in Uganda of coffee, the Rizal Mountain, the Moon Coffee. And the organization of farmers who actually registered this GI was funded by the European Union. But the people who were at the forefront of even drafting documents to file an application were not lawyers. And there needed to be legal mind to guide the right. Right now, we work with some there are very many products in Uganda, indigenous products, that can qualify, that have the potential to qualify as GIs. Paula has supported URSB to come up with a training manual on GIs. And these are some of the documents I think lawyers can approach us and, ask. We can share these documents for purposes of, acquiring knowledge and getting more skills in the landscape of intellectual property. Then traditional knowledge. This is also an area where lawyers can actually partake. Like I said, we are in the final stages to have, because right now the documents that are supposed to go to the Cabinet Secretariat are with the Minister, the Honorable Minister of Justice and Constitutional Affairs. But, in protecting and preserving our cultural heritage or traditional knowledge, and also commercializing some of these benefits, there is what we call the benefit sharing, arising from utilization of genetic resources and traditional knowledge. And these communities need the legal minds to help them draft benefit sharing agreements. So lawyers here, I can assure you that intellectual property has a lot of potential. Just take interest and you will benefit a lot. Thank you.
Thank you so much. I believe Ms. Mercy is going to be very happy that you actually spoke up in her absence, Mr. Oko. And I think right now we have to wind up. And I think just on that point, Judith, maybe just give us some final thoughts, just to add on to what was said. What any advice you would give to the next generation of, IP lawyers who want to make an impact in this area. Just your final thoughts, and we'll be ready to end our session.
I think as a closing remark, maybe just take into account everything that has been shared, in the discussion today, but also challenge yourself to keep abreast with the different changes in this space. That's the challenge of any IP practitioner, to just keep challenging yourself to see how you can adapt and be able to better advise your clients and the communities that are navigating this space.
Thank you so much, Judith. And I would like to thank my panelists. Thank you so much. I'll give you each, 1 minute to give your final thoughts. Just your final thoughts, because we're out of time, and then we can close.
Thank you, colleagues and those that are online. I was actually asked to make an announcement without payment on behalf of URSB that those of you that have IP that could benefit from the IP enforcement unit, please get in touch. They are active, they are violent, they are aggressive. They will recover your IP. Madam Nawatanzi, please stand up so that people can see you. She represents that unit. She's not violent, but she's very effective. They will help you in cases where your client's IP, you have counterfeit goods, that kind of thing. Please reach out to URSB. Thank you very much.
Yeah. Today I learned a new word from Council Paul, transactional IP. And they said most IP lawyers are engaging in transactional IP. I tend to agree. And if we keep doing things the same way and expect a different result, that is insanity. So it means the IP lawyers need to do something different. I was sharing with him earlier. He showed up in Naro one day, and things changed in Naro. I will not tell you why. You'll engage him and ask him. Things changed. It's simply because he decided to do something different, and it caused a change. So let's be proactive and do things differently. The opportunities are there. Thank you.
Doctor?
Thank you. I think URSB is at the pinnacle of IP practice in Uganda as the government IP office. Why don't we strengthen the database of IP practicing lawyers in Uganda? I know URSB already has that database, but something akin to WIPO Green, that you have the practicing lawyers, you have the IP owners, you have the innovators, and all those who really need these lawyers, and just connect the dots together so that we can improve the practice in that regard. So that would make IP much better in Uganda.
Well, thank you so much for the advice, from encouraging us to reinvent ourselves, keep up with the times, and also some great advice to URSB. And at this point, I would like to thank my panelists for honoring the invitation, giving up your time, and coming here and giving us such incredible knowledge from you. I'd like to thank you guys, our participants, for honoring also the invitation and ensuring that we were not talking to the chairs. I am absolutely happy that, this place is, full online, it's busy, and I love it for us, honestly. I really do love it for us, and I appreciate you. And maybe in line with what Dr. Nakosa talked about, if you've not yet registered with URSB, as an agent, you should do that. It's a very, very easy process, and it's online. And trust me, it's a credibility that you can actually add to everything else, because these days when clients are looking for IP lawyers, they want to know whether you're registered with URSD. So if you've not taken taken that up, you can actually talk to even counsel or go today, and it's a very easy process online. Once again, I would like to thank you so much. The panelists are around. If you have any other questions, any concerns, feel free to approach them as we move into our next session. Thank you so much.